Criminal law. Causation. Causation refers to the inquiry as to whether the defendant's conduct, or omission, caused the harm or damage. Causation must be established in all result crimes. This includes murder, manslaughter, ABH, GBH and criminal damage. Causation in criminal liability is divided into 1. Factual causation and 2. Legal causation. 1. Factual causation. Factual causation is the starting point and consists of applying the but, for test. In most instances, where there exist no complicating factors, factual causation on its own will suffice to establish causation. However, in some circumstances it will also be necessary to consider legal causation. Factual causation is established by applying the but, for test. This asks, but, for, the actions of the defendant, would the result have occurred? If yes, the result would have occurred in any event, the defendant is not liable. If the answer is no, the defendant is liable as it can be said that their action was a factual cause of the result. This can be seen in R.V. White, where the defendant put poison in his mother's milk with the intention of killing her. She, however, died of a heart attack on the same night, unrelated to the poison. So, but, for his actions, she would have died in any event. The defendant was not liable for murder, he could only be liable for attempted murder as his actions did not cause her death. 2. Legal causation. Legal causation consists of 1. The result must be caused by a culpable act. 2. The act of the defendant need not be the only cause. 3. There must be no novus actus interveniens, and 4. The defendant must take his victim as he finds him. Legal causation requires that the harm must result from a culpable act. In R.V. Dalloway, the defendant was not holding on to the reins whilst driving a horse and cart. A child ran out in front of him and was killed. The defendant's culpable act of not holding on to the reins was not the cause of death, as even if he had been holding on to the reins he could not have stopped in time. However, this does not apply where the offense is one of strict liability. In R.V. Williams, the defendant remained liable, despite the fact that the culpable act of not having insurance was not the cause of death. The defendant's driving was impeccable when the child ran out in the road. The defendant's action need not be the only cause but must be more than minimal. In R.V. Benge, the defendant remained liable even though the death may not have occurred if the train driver and lookout man were doing the job correctly. If something happens after the defendant's act or omission, the later act may break the chain of causation. This is known as a novus actus interveniens, that is a new intervening act which breaks the chain of causation. Different tests apply to decide if the chain has been broken depending on the intervening party. The act of a third party will generally break the chain of causation unless the action was foreseeable. In R.V. Paget, the defendant fired shots at the police and then used his pregnant girlfriend as a shield when they returned fire. The defendant was liable for her death as the actions of the police were foreseeable. Where the act is of the victim, the chain of causation will not be broken unless the victim's actions are disproportionate or unreasonable in the circumstances. In R.V. Roberts, there was no break in the chain of causation where the woman jumped out of a moving car to escape the sexual advances of the defendant. Contrast the case of R.V. Williams and Davis, where a male hitchhiker jumped out of a car driven at speed, as he feared the defendant was going to steal his wallet. His actions were deemed unreasonable and disproportionate, breaking the chain of causation. Where the victim is an adult of sound mind and makes a decision which causes death, this will break the chain of causation where the decision was free, deliberate and informed. In R.V. Kennedy 2007, the victim's decision to self-inject the heroin prepared and supplied by the defendant broke the chain of causation. In R.V. Wallace, the defendant threw a glass of sulfuric acid over her ex-boyfriend. This caused horrific injuries. He was left disfigured, partially paralyzed and in unbearable pain. He returned to his home country of Belgium where euthanasia is legal and made the decision to end his life. The trial judge ruled that this decision had broken the chain of causation, so the defendant could not be tried for murder. The prosecution appealed. The Court of Appeal allowed the appeal and stated she should be tried for murder. The jury should consider if his decision to end his life was within the range of responses which might have been expected from a victim in his position. Where medical intervention contributes to death, the courts have been inconsistent in their approach. In R v Jordan, the court looked at whether the wound was the operating cause of death. The defendant was not liable as the stab wound was healing when he died from an allergic reaction to an antibiotic. The same approach, but different outcome, applied in R v Smith, where the soldier was dropped twice and doctors failed to diagnose his punctured lung. The defendant remained liable as the stab wound was the operating cause of death. However, in R v Cheshire, the defendant was liable despite the fact the wound was healing. The defendant shot the victim in the leg and stomach. The hospital gave him a tracheotomy as he had difficulty breathing. He died from complications arising from the tracheotomy. The court departed from Smith and Jordan and considered whether the defendant's actions were significant in causing death. His action in shooting him could not be said to be insignificant in causing his death. Therefore, he remained liable. Under the thin, or eggshell, skull rule, the defendant must take his victim as he finds him. This means if the victim is particularly vulnerable, the defendant is fully liable for the consequences, even if an ordinary person would not have suffered such severe consequences. For example, if D commits a minor assault on V who has a heart condition and V suffers a heart attack and dies, D is liable for the death of V even though such an attack would result in no physical harm to someone without a heart condition. This rule applies irrespective of whether the defendant was aware of the condition. In R v Hayward, a husband was liable for causing the death of his wife when he chased her out of the house and she collapsed and died. He hadn't physically touched her but had shouted threats. She suffered from a rare thyroid condition which could result in death if she was exposed to physical activity and stress. The thin skull rule also applies where the victim has refused medical treatment which would have saved them. In R v Holland, the victim did not seek medical attention for his cut finger and refused to have his arm amputated when gangrene set in. The defendant was liable for his death. Similarly, in R v Blower, the defendant was liable when the victim refused a potentially life-saving blood transfusion on religious grounds. In summary, causation must be established in all result crimes. Generally, an application of the but, for test will establish causation. In some cases, legal causation may be required. The result must be caused by a culpable act. It need not be the only cause but must be more than minimal. There must be no break in the chain of causation and the defendant must take their victim as they find them. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.